Okay. So in these sections, from section 35 to 42, we are going to discuss on provisions for secrecy direction. Okay. So what is section 35 says? Secrecy direction relating to invention relevant for defense purposes. So it means that any invention which will be important for defense purposes, this direction will become active. So if invention is relevant for the defense purposes, controller will give direction for prohibiting its publication. So note, what are things being prohibited? Number one, publications or any information with respect to invention or communication of information. So you cannot do anything. Once this secrecy direction is on, you cannot do anything. So controller will prohibit that secrecy direction is given to this patent application, and you cannot do anything. You cannot publish, you cannot write anywhere, you cannot inform in anywhere you can do. Controller will inform central government, and central government will consider the application. So central government usually gives the controller a list of areas which are important for the different purposes. So whenever we file any patent applications, so that patent application, they look for those areas. And if it falls on that area, then controller will himself give direction, and he will also inform central government that this application, which was filed yesterday, or as the case may be, comes under the list of shared with me, and then government will review. If they find the invention is not so prejudice, means if it's not harmful, if it's not the related defense, the central government will inform controller, and controller will revoke secrecy action and inform applicant. So they will revoke the secrecy action and will inform the applicant. If central government feels that any application is relevant for defense purposes, although controller has not imposed secrecy direction. So if the controller has not imposed secrecy direction, but if central government feels, so any time before grant the patent, secrecy direction may be given. So this is a summary of section 35. Okay. In section 36, it says that the secrecy directions are reviewed periodically. So all directions are reviewed by central government at the interval of 6 months. So once they give a secrecy direction, so what is the problem with the secrecy direction? That once the secrecy direction is given, our patent application, you don't know what is going to happen, if it will ever get published or not. So that is the challenge, means you will not get published. It may go on and on. But good part is like the central government will review at the interval of 6 months. Every 6 months they review it, and or if you make a request by the applicant to controller, they will also review. If you make a request, then they can also review. Meaning, if you wrote something in the specification or in the claims which appears that it is important for the defense, or it involves something to atomic energy, something like those things, then you need to say that no, this is not for defense. This compound is being used, but this is for the medical purpose and everything discussed. So those kind of claims you can make. Or in case the foreign application, if the invention was published outside India, then controller may consider situation and revoke the secrecy action. And if you say that this invention, same invention, is a part of convention application, and this situation arises if, for example, the case like multinational companies. So they have R&D in India, they have R&D in other countries, and from other labs, they filed a patent from there, and it was published, and then it came to India, and then they are filing within 12 months. They are coming to India and to the filing, and then if you can say that to controller that the foreign application has already been published, and then the controller can revoke the secrecy direction. So because till the secrecy direction is on, you cannot give any publication, you cannot do anything. So it will come. What will happen? All direction regarding the review of secrecy direction of central government are communicated to applicant by controller within 15 days of receipt of information. So whenever a government is reviewing the applications in a normal case, so if the government is telling the controller that secrecy action should be removed, or if government feels that secrecy action should continue for another some months, so any decision that is communicated to its controller, the controller within 15 days will inform the applicant. Okay. So questions, what are the questions asked from section 35? So from section 35, it can be asked that if secrecy direction is on, what is prohibited? So publication or any information respect to invention or communication information. So all these things are prohibited. We cannot do anything. Okay. And when the secrecy action is imposed, anytime before grant of patent, it can be imposed. Another question that can be asked: can central government impose secrecy action although controller has not imposed? True or false? Yes. Even the controller has not imposed a secrecy action, central government can impose secrecy action. Okay. So these are the question can be asked, and the similarly scenario can be presented in the second paper where they can say that what to do and how much time it will take. So those kind of questions. Again, this 15 days and 6 months. These the point of where the question can be asked. At what interval central government reviews secrecy direction? So 9 months, 12 months, 3 months, and 6 months. So the answer is 6 months. At the end of the 6 months, they will review the secrecy direction. After how many days, within how many days controller should inform the applicant? So 30 days, 7 days, 21 days, 15 days. So the answer is 15 days. Okay. So these are the questions are asked in the paper 1 and paper 2. Okay. Question number 37. Consequence of secrecy action. So once the secrecy action is given, what happens? The controller shall not pass order for refusing grant of patent. Controller will not give any order for refusing patent. The application may proceed up to the grant, but will not be published, and patent application will not be granted. So this is a problem. Once the secrecy action is on, then whatever is happening within the patent office will continue to happen, but it will proceed to the grant stage. But generally, after it is granted, it gets published. So that is not going to happen. It will not get published. Okay. Even after the 18 months expiry, after 18 months, that needs to publish abstract and other details are published. That will also not happen, and it will continue to proceed. Examination will happen, then some reply will happen, FEI will be issued, everything will happen, but it will not be published even after the grant. If secrecy action is under force and the patent application found in order for grant, any use of invention by central government under section 100, 101, 103 will consider if patent has been granted. So although the secrecy direction is on, okay, I cannot inform, but government can use it. This is the provision. Government may pay patentee some solatium based on invention if government feels that patentee has suffered hardship due to this secrecy direction continuation. So government can pay some money. I have no idea how much money they pay, and it depends on a case to case. So that is a detailed understanding is required. But the criteria is government will pay the patentee some money if he feels that because of continuation of this, he has spent money in the the R&D, then he has spent money for the drafting, he has spent money for the filing, all money he has spent, and he is not able to convey to public, he is not able to use, he is not able to make any product after those. So considering those and how much could be everything, government can pay something. But even the secrecy direction is on, government can use the patent if it is in order for grant. Means if it reaches the grant, it can use the patent as if it is granted. So these are the consequences of secrecy direction. So question can be asked on section 7 that can government use even when the secrecy direction is on? No, government cannot use. Yes, government can use it under. So answer is yes, government can use it. So these are the things. Once secrecy direction use is on, controller can refuse to grant the patent. True or false? Yes, I'm asking the question. If secrecy direction on, if secrecy direction is given, controller can refuse to grant the patent. True or false?
False.
False.
Correct. Controller shall not pass order to refuse grant a patent. So this is the kind of question can be asked from this section. Okay. So we proceed ahead. Section 38, what it says?
Sir,
Yes.
I have a question.
Yes, please.
Section 37. Section 37, if second A, any use of the invention by central government under section 100, 101, 103 will consider as if patent has been granted, and it can be used by a central government. So in that case, they pay to the patentee?
Yes, yes. So this is what it says, that if they use it, if the central government is using it, okay, then they will pay to patentee. Some
Okay.
not, and but how much money they pay, I have no idea, but they will pay.
Okay. Okay, sir. Thank you.
Again, there's a clause. If government feels, so always they have some loopholes in the laws. Government say I don't feel. Then,
So they are acquiring someone's patent, and even that, if they will feel like so.
right.
So,
So I mean, say for example, I made a patent which is applicable in missiles, right? I made a patent. It may be coating, but coating could be useful for defense purpose, coating the missiles. And then government feels, this kind of coating can be used only in missiles, and this will not be used in other purposes, but can be used. But missile is the most appropriate place where it can be used. Then they will issue a secrecy direction that you cannot publish this idea in the public, and then secrecy direction is on. They are not going to revoke secrecy direction, and government starts to use that coating composition for the missile manufacturing. Okay, so because they are using this for the missile manufacturing, they will pay some solatium to the patentee. They will decide how much to pay, but they will pay some solatium if the government is using it. Okay, but only if the patent has been found in order for grant. Okay, if patent does not reach to the order of grant, then the patentee has no right, correct?
yes.
Only my right starts if the patent has been granted. So patent use as if it is granted. So because patent is granted, so patentee has the right to right with the patent, and therefore government will pay some money to them.
Okay, sir.
Okay. Section 38. Revocation of secrecy direction and extension time. So 38 says that controller may give extension of time on case-to-case basis. Okay. So this is the I mean, if the secrecy direction is on and because of that some steps could not be performed, then control will give extension. It will depend on when the secrecy direction became on, but such extension time will not be more than the time period of secrecy direction, and rule 72 to we do refer. So it says that if the secrecy direction is for 1 month and you want to extend some time 2 months, that is not be considered. So extended time will not be more than the time period of secrecy direction. So if it's 2 months, then only 2 months. And again, there are some time limit for performing certain act, as we're discussing always. So there are some time limit, but you could not perform those because of secrecy action, and then you want to have extend some time or you want to more some time, then controller may extend time depending on the case, but the time period will not be extended more than the secrecy direction according to rule 72.2. Okay, so here question can be asked here. Okay, that if the secrecy direction is there, okay, then controller can extend time. So they can write that time equal to the period of secrecy direction, more than that, less than that, or something like this. They can ask in any way. But remember this concept. What is the concept? Concept is that they will not extend time more than the time period of secrecy direction. Again, they can ask that the extension of time due to secrecy direction is according to section, which section? Section 30, 40, 50, 38. So that is section 38. So therefore, we need to remember that controller can extend time if there is a secrecy direction according to section 38. So question can be asked in first paper regarding this. Okay. Section 39. Resident not to apply for patent outside India without prior permission. Okay. So anyone, if there is any inventor in the patent application who is from India, then you cannot apply for the patent outside India. Means you need to fulfill this condition if you want to apply outside India. Condition 1, an application for same has been made in India and wait for 6 weeks. 6 weeks before application outside India. So section 39.2. 6 weeks. It is not 6 months. Okay. Be careful. So question can be asked that before applying outside India, one need to wait 6 weeks, 6 months, 15 days, 15 weeks. So correct answer is 6 weeks. You need to wait for 6 weeks. That is the correct answer. And another criteria is that if there is secrecy direction, then anyway you cannot apply outside India. Okay. You can apply only if the secrecy direction is revoked. Okay. And if ever you want to make application outside India, okay, then what you need to do, you need to fill form 25 according to rule 71, and fee is 1,600 for natural or small entity and 8,000 for others, and the time within which controller will give his consent is 21 days. For the administrative defense, 21 days from the date of consent from government. Okay. So if I want to file application outside India, okay, meaning I have not filed any application in India, okay, I directly want to file application outside India. So the scenario could be like sometimes the patent that I'm going to file is not patentable according to section 3 in India, but it may be patentable outside India. For example, new use of known substance. This is not patentable according to section 3D, but other countries it may be patentable. They may allow new use of known substance. Okay, but I don't want to file patent in India, because anyway if I file in India, they will reject my patent on the basis of section 3D. So I directly want to file WIPO application, or I want to find any convention countries where it is possible. So in that case, what I need to do is that I need to fill form 25, pay the fee of 1,600 or 8,000, the case may be, and then wait for 21 days. So within 21 days, we will get a reply from the controller saying that we have considered your application and you may file. And so why they are doing it like this? Because you are not filing patent in India, so government cannot understand if your patent application is important for defense purpose or not. Okay, if you file patent in India, then they will come to know if it is relevant for the defense or not. But if you don't file in India, they will not come to know. Therefore, they have made the provision. So we need to file application, and that application, Rule 25 application, there we need to give the entire patent application with the claims, everything. That complete specification is given to them, and they review. It's not like we feel 25 saying that I want to fill this, I want to file. No, we give all the details with them to the patent office. They review our entire complete specification and see, and if they feel that it is relevant for the defense, again they will, this secrecy action will become on. Okay, and for example, they impose secrecy direction, then 21 days is gone. I cannot say that within 21 days you must give reply. It says 21 days from the date of consent from government. So controller will inform government, and government may take, say for example, 1 week, 2 week, or 6 month time. Okay, and then after 6 month time, government says that okay, now we think that he can proceed. So for the date when government tells a controller that he may proceed, from that date 21 days. Okay, so here also section 39 is a very favorite sections, and it is being asked in interviews. It is also asked, this form 25 is asked in paper 2 discussion part, paper 1 objective type. This 21 days time limit, you will see some questions where this time within which controller will give his consent when applied for filing outside India, and Form 25 is 30 days, 40 days, 21 days. So answer is 21 days. This section shall not apply in relation to an invention for which the application for protection has been filed in a country outside India by a person resident outside India. Okay, if there is scenario like there are multiple inventors in a company, you have R&D in India, you also have R&D in outside India, but R&D team outside India, along with all the inventors from outside India, and no one from Indian R&D team, they have already filed an application. And again, when it is coming to India, they are including someone from Indian team during filing in India. That time it is not required. In that scenario, it is not required. It is already said, because it is already publicly known. So that is not, they're not required. Okay. Section 40. What are the liabilities? So contravention of section 35 means secrecy action is on, but you published somewhere in a journal article, or you disclosed somewhere, you talked in a press conference about your invention. Your invention was for coating on the missiles. Government says secrecy action on, you cannot publish, but then you went on news table and said that yes, I filed application for this. So you are contravening the section 35. Section 39 means before completion of 6 weeks, you file a patent and in India, but you miscalculated your application timing, and before 6 weeks, before expiry of 6 weeks, you file patent outside, either WIPO or anywhere in US, anywhere file, or like you didn't file application in India, you don't follow this Form 25 process, and if you follow Form 25 process, you did not wait for the controller consent, you file the patent outside India. So whatever the case may be, as it is given in section 35 and 39, if you do not follow, okay, then what will happen? Patent shall be deemed to abandon, and the patent, if granted, will be revoked. Under section 64. So even if the patent is granted, that patent will be revoked under section 64 immediately. Okay, so you lose the patent if either government comes to know, controller comes to know, or any third party comes to know that this is the case and this has been done, then that your patent will revoke. Okay, so you lose all the rights as a patentee. Okay, so the section 40. So liability for contravention under section 35 and 39 is given in section 41, 42, 40. So answer is section 40. So this kind of question can be asked. So you can expect question directly. They will name certain event and they will ask this event is mentioned in which section. So therefore, remembering section is very important. Section 41, finality of order of controller and central government. Okay, what it says that central government or controller, if they give secrecy direction, no one can put any question. You cannot go to any court and say that why they have given secrecy direction. They should not give secrecy direction. This kind of question you cannot ask, because the Patent Act 1970, it gives right to the control of central government regarding secrecy direction, and that will not question in any court. Section 42, saving respecting disclosure to government. So here what it says that controller has full right to provide information to central government regarding patent application for examination of secrecy direction or revocation of secrecy direction. So section 42 gives right to controller, that controller can I mean, you cannot go to controller and say, why did you inform the central government? Why? Who gave you right to inform the central government? I filed patent in patent office. You are the controller. You should process it. And then, if we have not given to central government, so this kind of question you cannot make argument with the controller, because section 42 gives right to controller that he can inform central government regarding the application, and also tell to examine for secrecy direction is not or not. He can discuss with the government. So this is right is given under section 42. So very quickly we have summarized and covered both the sections. They're very important. Section 35 to 42, provision for secrecy direction. So in summary, section 35 deals with regarding secrecy direction is given, and once secrecy direction is given, you cannot publish. Section 36 says that this direction will be reviewed after every 6 months, and any communication that controller gets, he will communicate to the applicant within 15 days. And the consequence of secrecy direction is that like the controller will not refuse to grant, application will proceed to the grant but will not get published. And if the patent is in order for grant, then government can use it, and if government uses it, they will pay the patentee some amount, okay, based on the case to case basis. And 38 says that if the secrecy direction is revoked and some extension of time is required, then controller will decide case to case basis to extension time for performing that task, but that extension will not be more than the time period for which secrecy direction was there. Okay, rule 72(2). And section 39 it says that no one should apply outside without prior permission. Okay, so there are scenario, if you file patent in India, then after 6 weeks you can file outside India. Then in that case you need not follow this form 25, all these things. You just wait for 6 weeks and then file outside India. Okay, and if there is secrecy direction, then you can file outside India. If secrecy direction revoked, then you can file outside India. And if you do not want to file in India, due to many reasons, one reason is like your patent application is not invention or is not patentable as per the Indian Patent Act 1970, or you think that filing patent and maintaining patent in India is a waste of money because there is no mature or proper market for a product in India, or I am not planning to open any manufacturing plant in India, so why should I bother to file in India? So you don't want to file in India, as the case may be, or your company has that they always file outside India first and then they come to India. They follow the PCT route, they file PCT application and then come to India. Whatever the case may be, whatever your patent strategy, you don't want to file in India, then you need to follow the second step, fill the form 25, okay, according to rule 71, and pay the fees as required, 1,600 or 8,000, and then control review. And during that you need to submit your entire complete specification, all the details you need to fulfill. And then within 21 days, you will get a reply from the controller that your there's no security action, and you can go ahead. And then once you have that letter, you receive letter, then immediately you can file outside India, either PCT route or you can approach another company. And section 40 says that if you do not follow 35 or 39, then your patent will be abandoned, and even if it is granted, it will be revoked. And 41 says that the order of controller of central government on security action is final. That cannot be questioned in any court. You cannot go to any court and say that this should be revoked. And 42 says that controller has a right to inform central government. Very simple language, and you can very easily remember this. Just go through this once or twice, and you're done. Okay. So with this, we have completed this section on secrecy direction. Any question on that? Then we'll move ahead with the grant of patent and right confer thereby. So 43 to 53. Any question on this?
No, sir.